Welcome to Stolen, the world's greatest eminent domain podcast. Legally, the government has the power to take your property, but most people don't know what to do when it actually happens. If you don't respond correctly, you could walk away with far less than you're owed. And when that happens, in effect, the government steals your property. Our mission is simple: protect property owners, make sure they get the compensation they deserve. The government will steal your property, but only if you let them. Hey, welcome to Stolen. It's the world's greatest eminent domain podcast. I'm Chad Brown. I'm your host, and we are here once again talking about really important issues that impact property owners who are being impacted by eminent domain and condemnation issues. I am with my trusty sidekick, prolific writer, singer, songwriter.
Oh, man. Okay.
Caleb Wheeler. Caleb, how's it going?
It's good to be here, Chad. Thank you for having me. Everything's going great.
That's good.
So far.
That's good.
So far.
Today we're talking about highest and best use in eminent domain valuations. I mean, that's as exciting as it sounds, except we were talking about earlier about it's exciting because really it's where the money is. We talked about this earlier. Show me the money. Show me the money. Right. Show me the money. Jerry Maguire. And it's great that we have Caleb.
Shout out to Tom Cruise.
Yep. Because, yeah, okay. So Caleb, like Tom Cruise in Jerry Maguire, is married to a woman who has a child.
Yes.
And he's great.
He's my buddy.
That's right.
He's now a dad. He's a boy.
Serious.
So, yeah.
Just show me the money.
That's right.
All right.
That's right.
Enough about Caleb's background. We're going to have him sing one day. He's got a great voice. We haven't figured out how to work that in the show yet. But it's coming.
Show me the money.
Okay. We can talk about it.
Yeah. That is big. That was a joke.
Highest and best use, eminent domain valuation. What does that even mean?
Right. So highest and best use, Chad, is simply this. It is the reasonable, probable use of the property that's legally permissible. So we're looking at the highest valuation that a property can have based on the use that is legally permissible and reasonably attainable. So there's essentially, when it comes to highest and best use, there's a 4-part test that's used across the entire country. And that test can be, or is, legal permissibility. So is it legally permissible? Is this use of the property legally permissible? Is it financially feasible? Physically possible? Is it maximally productive to the owner? And we can get those more in depth later, but that's generally the test that people are going to look at when they're trying to value their property.
Okay, so we're going to talk about some examples down the road.
Sure.
But just to at a really, really basic level, highest and best use is saying that we don't just look at the property necessarily as we find it today at the time of the taking or the time of the eminent domain action. What we're going to look at when we're trying to value property, because it's a valuation issue, we're going to be looking at what is the highest and best use of that property to make sure that the property owner is compensated fairly, and compensating them fairly is a product of them being able to get the highest amount for the property in a reasonable way it could be used.
Right. Exactly. It's essentially when the condemnation action is filed, when the government or its agents file a lawsuit against the homeowner.
Okay.
That is a timestamp. And that timestamp that is the time that we value the property at. Okay. But however, a misnomer a little bit, because now you're looking to the future. Right. What would a reasonable developer or would an investor look at that property for? And is those things the uses that these investors, developers, whatever, entrepreneurs, whatever their value is, whatever they're looking to do in the future, that 4-part test would apply to it to see how reasonable it is. And then we do that. That's how we get to the value of highest and best use.
Okay. So, but one thing you have to understand is the highest and best use, like in a residential case, might be what it is. So
absolutely.
It could just be as a single family home. That could be the highest and best use.
And more often than not, it usually is.
Okay. All right. So in residential cases.
In a residential case.
Okay. We're just talking about commercial cases down the road. That's coming soon. Yes. Coming soon to a podcast near you will be our series on introduction to commercial eminent domain taking. So be on the lookout for that.
Absolutely.
So, okay, the risk of you talking about ancient Rome and the Magna Carta Can you give a little bit of history,
Oh,
of highest and best use? Where does it come from? Obviously, we've talked about this.
yes.
In the Constitution, it establishes the right to condemnations actions and establishes compensation for property owners, just compensation based on fair market value, all that. But that doesn't sound like highest and best use. So can you please briefly tell us where it comes from?
Yeah. So I actually thought about Rome in the shower this morning, actually. So I was like, so incredible. So when it comes to eminent domain history, so when it comes to eminent domain and the issue of highest and best use and how highest and best use applies to eminent domain, we really start the analysis at Boone Company versus Patterson. I'm not going to go into the case details very deeply, but essentially there was the defendant, who was the person whose land was being taken from them, owned a couple of islands on the Mississippi River in Minnesota. I've been up in that area. It's beautiful. It's a beautiful area. And logging was a big part of the economy at that point. This is the late 1800s. And essentially the islands were perfect for a log boom, which is basically a fence in the river that's built off of these islands to basically accommodate these logs being floated downriver. Now, the issue is simply this. Do we value the land as just a couple of islands in the middle of the river? Or do we value it as something that's specially utilized or specially adapted for this log boom use? And so there the court said, because this land is specially situated, adaptable to this use, it's now much more valuable than just a couple of vacant parcels in the middle of the river. Okay.
That's absolutely wonderful. I'm sure we have a lot of property owners who are going to call us with islands in the middle of the river.
Exactly.
And they're trying to figure out how to maximize the property around some log.
Yes. If you have
other historical.
If you own a couple islands, please call us. Anyways, when it comes to highest and most profitable use of the land, there was Olson, the United States. Basically, that case revolved around the ability to store hydrostatic electricity, or basically this is a 1934 case. And essentially this case, the ruling that came out of that was the adaptability plus the reasonable probable demand of what was actually needed. So the courts were looking at this case, building up to our modern jurisprudence on highest and best use. They were looking at demand for a certain parcel of land, and does that essentially make it maximally productive? And then we have a Hawaii case. A lot of eminent domain jurisprudence comes out of Hawaii with our Supreme Court because of the limited nature of the property available in Hawaii. It's a couple islands. So with that being said, we have the issue of assemblage. Is there a reasonable probability that the highest and best use is tied to another parcel of land? Here in the McCandless case, it was tied to water being piped in from another property. But is that reasonably probable such that we can see a maximally productive use of that property through, in the McCandless case, Chad, it was, I think it was sugarcane fields. And so for the sugarcane, they had to have water from another property, but they had already been in negotiations. So because they'd already been in negotiations, the court allowed the evidence to come in, which showed that there was a maximally productive profit or use of the land from the use of sugarcane fields. So they got the award based on that.
So go back in the late 1800s, there were a bunch of cases in 1930s and 40s.
I think the areas were big, yeah,
and which also in some respects, correlates with the the sort of the industrialization of the United States, where you have a lot of just a lot of different things going on that end up impacting property. But the point is, the court stepped in and said, hey, we need to look at how properties can be used. What is their highest use? What is their best use? What is their most profitable use? And we should if we're going to compensate people fairly, we're going to give them just compensation. Then we have to be able to look not just at what the land is today, but looking at the potentiality within reason for what it could be.
Right. And the potentiality is directly related to, it all goes back to reasonableness and what a willing buyer would give to a willing seller of that property, and what visions or what capabilities that property has in the mind of that buyer.
Right.
Right. And so it goes to, it kind of discussing these things bit by bit, the 4-part test individually. We go into the legal possibility or legal feasibility, permissibility, legal permissibility, what does the existing law over that property actually say? Does the zoning allow for that highest and best use to be performed?
Right.
So you get to look at current zoning, but not only do you have to look at zoning, Chad, you got to look at the bylaws of a subdivision. What's the covenants and restrictions of that subdivision say? Or is there any covenants and restrictions? You have to look at local municipal rules. Is there a limit on the amount of sound that can come out of your property before it's a nuisance or deemed a nuisance?
So the point is that we're going to evaluate properties.
Right.
We're going to start with what the property is now.
Right.
But we're also going to be looking at other potential uses. But it's not, I think my property could be a diamond mine. So you give me $40 million. No, that's not how it is. It's what's reasonable based on the law, permissible uses, zoning. Is it financially? Is it even practical to do what you're saying?
Yeah. So a word on that real quick. So when it comes to financial feasibility, we're not talking about can the owner or potential buyers, anybody like that, can they afford to cause or to bring about this highest and best use?
Right.
It's not a question of affordability. It's a question of, is it a financially sound investment?
Yeah.
Is it a financially sound investment? And there's a couple ways to look at that, Jeff. You've got redevelopment cost. So if you have a barn, a dipping vat, if you got for cows, if you have a silo, whatever on that property, what is it going to cost to move this stuff off the property and then put back on what it is that would be the highest and best use? And is it cost prohibitive?
Yeah. So the issue is not, does the farmer who owns the vacant field that could be developed commercially financially able to be a real estate developer? The question is it financially viable to be able to take this property and convert it? And it may or may not be. It's an analysis. Okay.
It's an analysis.
All right. So why does it matter? Like what? Okay. I understand it's part of valuation. I think it's easy to see that using the highest and best use, obviously we're trying to get the highest dollar amount we can for our clients for this property to either fully or partially been taken. But generally, why does this matter in the domain?
Oh my goodness. Why does it matter? Well, again, it goes to this issue of, I call it highest and best use is a balancing act just to get some glasses. Okay. So I imagine a clown balancing on a tricycle or a unicycle just to get to some glasses to put on to look at something. So we're looking at this balancing act of interest to get the proper type of glasses to view a parcel. When I say parcel, I mean the property. So if highest and best use is how we look at the property to even get to the issues of valuation.
Okay, so to establish highest and best use, you're going to have to look at what are the proper comps for valuation.
That's right.
That's good, but that's going to be driven by what the highest and best use.
Exactly.
If the highest and best use is a commercial development, then you're going to use different comps, comparable properties for analysis than you would if it's just residential single family home.
That's right.
Directly related, that's going to be valuation methodology because you're going to they still use the same 3 core valuation methods, but a comparable sales analysis may not be the best methodology when you're valuing commercial interest in the property. It might be better to use income capitalization.
Exactly.
But I think at the core, the reason that it matters is what we're doing in eminent domain cases is looking at the property before and after. So what we're trying to do is establish that highest before number that we can. That is, at the time of the taking, what's the maximum value, because it's what's taken away from that value that's going to determine what our client's able to recover. So if you start with, obviously, just use simple numbers. If you start with the 20% impact on $100, you get 20. If you started a 20% impact on $1,000, you get 200. Well, I mean, that's 10x the recovery, but it's the same percentage of impact. So you really need to understand the proper starting points. Proper starting points going to be driven by highest and best use.
Yes, you're not even starting until you get the right highest and best use. A lot of appraisers, real estate appraisal manuals I think of USPAP, Yellow Book, AI's Appraisal of Real Estate, which is the Appraisal Institute's book, commonly referred to as the Bible of appraisals, right? The Appraiser's Bible. It all requires that the highest and best use be determined on a property before you even start the analysis.
Right. You know, what's scary is like so many, I don't know what stats show. 65% of people, residential property owners, never hire an attorney to help them in their domain cases. And there's no telling. I'd love to know what percentage of those people failed to pursue a recovery based on the highest and best use of that property, because they don't even know what we're talking about.
Well, absolutely. And when it comes to, I've had a case where we had it was a residential property owner, lived in a single family home, but the highest and best use was actually as commercial, as a office building or mixed use building, because his property sat in the middle of multiple office buildings off of a main street.
Yeah, and you got your client who comes in and thinks they just have this little 1,200 square foot old house that's not worth anything, but actually it has value as a commercial interest, far in excess of what it would have as just a single family home. Okay, let's do this. Let's go through. I'm gonna just, man, we're short on time again. I'm gonna pop out some general fact patterns. Okay. And you just give us an illustration of what that might do. So rather than going through and looking at all the different ways highest and best use can be evaluated or accomplished in a case, let me just throw some title. I'm going to throw a word out at you, and you give us an illustration so we would understand it. Okay. Mixed use zoning.
Mixed use zoning on a residential property or a commercial property doesn't really matter. Mixed use zoning and highest and best use. I mean, to me, we love that.
Right.
That's good. It's good stuff.
Tell us what mixed use zoning is.
So mixed use zoning is, it can be either residential. Typically, it's either residential or like commercial. And oftentimes we see it in the context of like limited business. So like office buildings, like small office buildings, strip malls, small strip malls, sometimes even schools, stuff like that. So mixed use zoning, we have that. And so when you have a house, that's in a mixed use zoning, sometimes we're going to be looking at, depending on the nature of the neighborhood and the current zoning regulations, so defining what mixed use is, and then also looking at past allocations of zoning. And in that area, we can oftentimes try to get that highest and best use bumped up to an office building if that highest and best use is actually the maximally productive use of that property.
Right. So
we have to also be looking at that. We're always in the context of that 4-part test and looking to see what is the last step you're always going to look at, is it maximally productive.
But in a mixed use zoning scenario, you have property that's often being used as residential, but it's already been zoned to be commercial, which is typically going to be more value. Okay, let's piggyback off of that.
Okay.
You hit on this a second ago. Residential property converted to office use. Is that pretty common?
Yeah, that's very common, actually. I mean, even in our old office, just an example, we had an office off of Broad Street in Statesville and North Carolina, and that was a home at one point. That was a literal house built in the 1920s for a family.
Yeah, no, I owned it.
Yeah, he owned it. So with that being said, most of those houses now on that street the zoning was changed to accommodate for office space, and most of those houses are used as offices now.
Right.
And so very few of them are actually lived in by single family, units. So
how about rezoning? There's a lot of zoning issue. Let's talk about rezoning.
Rezoning. So when highest and best use, zoning, rezoning. The question that I immediately have when I hear that is, how probable is that rezoning going to be?
Right.
Because if the zoning is not very probable, it's speculation, then based off of speculation, based off of no real facts, then the court's going to laugh at you.
Right.
What we want to see is the rezoning imminent, or is it reasonably probable that it can be accomplished? And the way we do that, Chaz, we look at the circumstances surrounding past rezonings in that same area.
And there's some pretty big cases. I'm not getting what they are. There's pretty big cases on this issue. So what you're saying there is, where in a mixed use, you already have multiple types of property usage allowed within the zoning. Rezoning, what you're saying is it's zoned one way, but we believe in the future it will reasonably be zoned differently. And in that different zoning, I would have different opportunities for use of the property that would be more valuable.
Yes, and it's on the defendant these condemnation lawsuits to prove that.
Right.
But with that being said, there's attorneys, Chad, that make a living just doing rezoning applications and working with developers in that aspect.
So not in the eminent domain, just
not
in
eminent
just in
domain.
real
No,
estate.
just real estate development in general.
Yes.
So that's a big practice area, and So
let's do one more. I've got a bunch here. We're not going to get to all of them. So I like this one though. It's renewable energy or mineral resource potentiality in a property. Like, what's that about?
Yeah. So a couple of things. Number one, zoning's got to allow for it. Number two, what's the public outcry going to be?
Right.
Because that's one of the elements kind of considered.
Well, like in Western North Carolina, for example, you have people whose houses sit on top of lithium deposits.
Right. Yeah. In Lincoln County, North Carolina, there's actually been some lithium found in that, the environmental concerns now that you have to deal with.
Well, yeah, but aside from all that, the issue just in the highest and best use would be saying, well, yes, it's just a residential home, but potentially I'm sitting on top of a lithium mine, and that might be way more valuable than just my residential home. Absolutely. So you still got to go through the 4 tests. But it's not speculation. Okay, perfect. All right. Let's wrap up.
Okay.
Got to be solid methodology. Can't be speculating.
You have to get somebody who has got an approved methodology, i.e. an appraiser, who has been trained in the methodologies and can show their work.
You got to meet the 4 steps.
You got to meet the 4 tests, the 4-part test.
4-part test.
Yeah, 4-part test to the highest and best use.
And you got to have evidence.
You have to have objective evidence that shows.
Yeah, it's just not
speculation. You cannot use speculation.
It's not the that's getting appropriate. It's not the guy down the street who thinks his property's going to be like this super duper commercial property, but really there's no way it's ever going to happen. The guy's delusional. Right. It's not about like some delusional property owner's vision of what could happen in some fantasy world. It's what really could happen reasonably with the property. But if that's there, you got to argue it because that's pretty good.
Reasonable probability.
Show to money.
Number one question.
HPU minute money. HPU. How's the best use?
Highest and best.
Show to you. All right. That's all the time we got. Sorry. Highest and best use. Super, super important topic. You've got to evaluate your property and see. You gotta have some vision. You gotta have some imagination. But mainly, you need to understand all the different ways property can be used, because if you can place your property inside a different framing for its use, then you're going to be able to maximize your recovery. That's all we got for today. Subscribe to Stolen. Tell your friends if they're dealing with eminent domain or condemnation actions. Check us out. Caleb, till next time. Yes, sir. All right, take care.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.